All right, good afternoon, everyone, and welcome to this webinar training titled Sentencing Guidelines in MAGS 101. My name's Catherine Pembroke. I'm the Administrative and Training Coordinator for the Maryland State Commission on Criminal Sentencing Policy, which we commonly refer to as the Sentencing Commission, or MSCCSP for short. Now, the sentencing guidelines play a significant role in supporting fair and proportional sentencing practice. Accordingly, your participation in this training, staying up to date on sentencing guidelines, it's really important because it helps to promote the consistent application of the guidelines. So please note that today's webinar, it is being recorded, and either this video or a similar webinar video will be made available on our MSCCSP training website. So if you have a colleague who was planning to attend, maybe couldn't, or if you ever need a refresher, please feel free to check out these training videos on our training page. So I want to quickly go over just some general webinar housekeeping. We are asking that participants remain muted throughout the course of the presentation. That's just to ensure that we get through it in a timely manner. We have a lot to cover today. That said, we certainly welcome any and all questions. I have two of my colleagues here with me today, Sarah Bowles and Bella Nocell, who will be answering any questions that you have through the chat box. So please feel free to submit questions throughout the course of the presentation. They will be happy to answer your questions. Coming through the chat box in a couple minutes, you'll probably be seeing a PDF of today's presentation as well. You can feel free to download it, save it to your computer for future reference. All right, so let's move forward and just quickly go over the agenda for today's training. I'm going to start by providing a very brief background about the purpose and goals of the Sentencing Commission, as well as the sentencing guidelines themselves. Then we're really going to get into breaking down guidelines worksheet completion. We're also going to look at some special applications that adjust the calculation of the guidelines in certain scenarios. Then I'm going to wrap up with a live demonstration in MAGS. I'm sure, as you are all well aware by now, we deployed an updated version of MAGS 12.0 on July 1. So I'm really going to try to highlight some of the key features and updates that were rolled out with that deployment. And then finally, throughout the course of the presentation, I'm also going to be highlighting and focusing on some recent guidelines updates. So to start, I'm going to provide some background information regarding the makeup of our commission itself. So in 1999, the legislature decided that a permanent independent sentencing commission should be created to have oversight over the guidelines. And thus, the Maryland State Commission on Criminal Sentencing Policy was born. So it was then created as a balanced board of 19 members from all three branches of government. The commission is currently chaired by Judge Dana Middleton from the Circuit Court for Baltimore City. The membership also includes 3 additional judges, including representatives from each of the 2 trial courts, and 1 appellates court representative who serves as the chief judge's designee. The remaining 15 members include a cross-section of criminal justice officials from the other 2 branches of government, as well as 2 public representatives. Appointed members serve terms of 4 years, and they are eligible for reappointment. So the MSCCSP, it makes decisions with respect to the guidelines after deliberating with the many stakeholders that encompass the Maryland criminal justice system, most, if not all, of its constituencies being represented here on the commission. So let's get down to the basics here. What is the purpose of sentencing guidelines? The sentencing guidelines are a mechanism to encourage proportional sentences. The primary goal of the guidelines is to promote consistent, fair, and equitable sentencing practices, whereby offenders who are adjudicated of similar offenses with similar criminal histories, they're treated and sentenced alike. The Maryland sentencing guidelines were designed to systematically account for the most common variations in offenders and their offenses. The guidelines help achieve proportional sentencing by identifying and assigning weights to core objective factors for consideration by judges in making sentencing decisions. The guidelines account for the most common, but certainly not all, characteristics of an offender and their crime that are most relevant to the sentencing decision, and they really help to provide a framework to allow judges to consistently assign the same value or score as their colleagues around the state for each of these legitimate legal factors. So to start, we're going to start with a poll question here. I have a couple scattered throughout the course of the presentation. They really are kind of our most frequently asked questions that we receive here at the commission. So talking a little bit about the scope of the guidelines themselves, I'm going to start with a true-false question. So Maryland sentencing guidelines are limited to felonies that are prosecuted in a circuit court. Is that true or false? I'm going to go ahead and launch a poll question. And you can go ahead and just make your selection. Your answer is anonymous. Again, this is just an exercise, some helpful questions that I want to highlight throughout the course of the presentation. So make a quick selection, and then I'm going to share the results in a moment here. So Maryland sentencing guidelines are limited to felonies prosecuted in a circuit court. All right, so let me go ahead and share the results here. All right, so 25% think true, 75% think false. So let's go ahead and take a look at the answer here. Now, the answer is false. They are not just limited to felonies prosecuted in a circuit court. They can also include misdemeanors, as well as traffic-related offenses, if it carries the possibility of incarceration. So let's take a look at the greater scope of the sentencing guidelines here. So the guidelines apply to criminal cases that are prosecuted in a circuit court. The sentencing matters that we see on the left-hand side, they require a guidelines worksheet. We refer to these as guidelines eligible sentencings. So these include circuit court original sentencings, jury trial prayers and appeals from the district court, only if a pre-sentence investigation is ordered, adjudications or cases adjudicated via a probation before judgment. This also includes the new type of PBJ pursuant to Criminal Procedure Article 6-220, subsection C. In addition to original sentencings, we also collect worksheets for reconsiderations, modifications, and 3-judge panel reviews, provided that the sentencing event involves a crime of violence, and if there was an adjustment made to the original active sentence as a result of the modification. So again, just to note, guidelines do cover misdemeanors as long as they kind of meet this category, be it that they're an original circuit court sentencing or a jury trial prayer or appeal from the district court if a pre-sentence investigation is ordered. Now, on the right-hand side, these are also sentencing matters that you might see prosecuted in the circuit court, but they are not guidelines eligible. So those are jury trial prayers and appeals from the district court with no PSI, if the offense carries no possibility of incarceration. So like reckless driving, for example, that's a common question we get. That's not considered a guidelines eligible offense because it doesn't carry the possibility of incarceration. Violations of local laws or municipal ordinances, the guidelines do not apply to probation violation hearings, criminal non-support or contempt cases, juvenile court adjudications, and then finally, they do not apply to district court sentencings. So now that every jurisdiction has onboarded with MDEC, I do want to note that we've worked with GIS to identify guidelines eligible cases requiring a guidelines worksheet. So here's a screenshot of a criminal docket from the Circuit Court for Anne Arundel County. And I do want to note, when looking at the docket, you can see that the guidelines eligible cases, they're marked with this MAGS yes indicator. So obviously indicates it's guidelines eligible and requires a guidelines worksheet. So I did want to point this out. I know some state's attorneys find it particularly helpful, just kind of as a double check to make sure that they are properly initiating worksheets for guidelines cases. Law clerks also find it helpful so they know what cases will need sentence information entered and worksheets ultimately submitted. So if you think this would be a helpful tool for you, please feel free to check out this MAGS indicator on the criminal dockets. All right, so starting to move towards guidelines worksheet completion, I want to talk about the purpose of the guidelines worksheet itself. So the first purpose of the worksheet is to inform the judge of the guidelines prior to sentencing. So Criminal Procedure Article 6-216, it indicates that the court shall consider the guidelines at sentencing. And in order to do so, a sentencing guidelines worksheet must be prepared. The second purpose of the worksheet is to provide data so that the commission can make informed decisions about sentencing policy. So Criminal Procedure Article 6-210 then requires that the commission collect the sentencing guidelines worksheet, automate that information, and monitor sentencing practice. So that's why it's especially important that we're getting as many worksheets, as much data as possible to help inform these sentencing policy decisions. So moving further into guidelines worksheet completion, I'm going to start by defining a single versus multiple criminal event. Now, for guidelines purposes, we defined a single criminal event as one or more crimes committed in the course of the same transaction. Now, some additional language that was added last year, it drew on some guidance that was provided by a 2022 Supreme Court opinion, and it didn't alter current guidelines rules, but we did think that it did help provide further guidance to practitioners when determining whether multiple crimes were committed during the course of the same transaction. So this language states, in determining whether multiple crimes are committed in the course of the same transaction, the person filling out the guidelines worksheet shall consider whether the crimes, 1, are committed close in time in an uninterrupted course of conduct, 2, occur in the same location, and 3, are similar in nature or intertwined. For example, whether they share a common scheme or purpose. Whereas a multiple criminal event, that means there's more than one criminal transaction committed over a period of time. Now, multiple criminal events being sentenced together, they may have occurred on the same date or different dates. But generally, offenses that occur on different dates are almost always going to be considered separate criminal events. Now, a sentencing event is defined as a sentencing disposition or hearing for an individual defendant conducted in front of one judge on the same day. So when you have multiple criminal events being sentenced by the same judge on the same day, they constitute one sentencing event, meaning that one set of sentencing guidelines should be completed for each sentencing event. I'm probably going to reiterate this point several times throughout the course of the presentation, especially when we get into the MAGS demonstration, because it's a common error that we continue to see in MAGS. But again, just important to note, multiple criminal events being sentenced by the same judge on the same day, they constitute one sentencing event. We're going to take a look at what that looks like in the next slide. I do just want to note that merged and null prost offenses are not included on the guidelines worksheet. Whoops. Okay, so here's an example that illustrates how one sentencing event may include multiple criminal events. So this example here shows initiated worksheets for 2 separate criminal events that are being sentenced by the same judge on the same day. I know the font's a little small here, so just bear with me, but I'll try to point out the important points here. So in the upper left-hand corner, this worksheet in the upper left-hand corner, you can see we have a distribution of PCP that occurred on July 10th of 2023. It has its own unique case number ending in 001. Also has its own individual guidelines range calculated for that distribution offense. Now, in the lower right-hand corner, we have an assault first degree that occurred several months later on July 25th of 2024 and has a different case number. Again, has its own individual guidelines range for that assault. Now, by guidelines rule, each separate criminal event should correspond to its own guidelines worksheet. So even if you have one adjudicated offense per criminal event, it is still correct for them to be populating on separate worksheets if they are being treated as separate criminal events. That's also a common question that we receive. However, since they are a part of the same sentencing event, there is still one overall guidelines range calculated between them. So I'm going to highlight all of this again once we get to the MAGS demonstration and show you exactly how to initiate this type of scenario properly in MAGS. So moving forward with the guidelines worksheet here, the next section I'm going to discuss is the adjudicated offense information. This is pretty self-explanatory. This is where we're capturing the date of the offense, as well as the adjudicated offenses in a given case. Now, the first 2 fields I want to point out here, where it says that this sentencing, the number of offenses and criminal events, it's important that you're correctly noting the proper number of criminal events when you're entering this information into MAGS, because the number of criminal events plays a critical role in guidelines calculation. It can definitely affect the calculation of the overall guidelines range. So you want to make sure that the number you're seeing in this box here is reflected properly once you've inputted all of that information in MAGS. Dropping down to offense title, you can see we have the adjudicated offense information. Based on the offense that you select in MAGS, you'll see the CJIS code populate, as well as the statutory maximum. If there were a mandatory minimum, that would populate here. And then whatever case number you enter corresponding to the offense that you had selected will populate here. Now, the last column I want to point out, it has the Roman numeral equivalents of 1 through 7 right here. That's the seriousness category column. I'm going to talk a little bit more about that and how critical of a role that plays in guidelines calculation. Now, many of you are probably already familiar with the general framework, but I do want to give a really brief overview of the basic premise of the guidelines. So Maryland has 3 separate sentencing matrices. We have one for property that you see here, one for person offenses, and one for drug offenses. Now, the guidelines were designed to take both offender and offense characteristics into account. So we can see on the left-hand side here, this represents the offense seriousness category column. Each offense in Maryland is ranked based on its seriousness, with 7 being the least serious to 1 being the most serious. And for property offenses, we can see that that ranges from a 7 all the way to a 2. Now, the top row represents the offender score, which we're going to get into in more detail later on, but it essentially captures components of an offender's prior criminal history. So let's say we have an offender who has no prior record. So they have an offender score of 0, and they've been convicted of a theft less than 100, which is a seriousness category 7 offense. So looking to this matrix, we can see that the recommended guidelines range would be probation to probation in that instance. So again, just a basic example to show how guidelines are calculated and also to highlight how critical of a role the seriousness category does play into the calculation of the guidelines. All right, so returning to worksheet calculation, the next section we're going to discuss is the offense score. Now, the offense score only applies to person offenses. Those are offenses that typically involve victims, such as an assault, robbery, as well as weapon-related offenses. Now, the offense score is a summary scale ranging from 1 to 15, and it measures the seriousness of a person offense based on 4 components. Part A being seriousness category, B, victim injury, C, weapon presence, and D, special victim vulnerability. Now, the first section here, the offense seriousness score, you can see it provides a conversion chart shown on the worksheet, whereby the least serious offenses, those being the categories 5 through 7, are assigned 1 point, all the way to the most serious, those category 1s being assigned 10 points here. Now, with regards to the offense score in the seriousness category of an offense, it's important to also note that generally any attempt, conspiracy, or solicitation, it's going to be assigned the same seriousness category as the underlying offense. There are some exceptions to that involving some of the more serious offenses. For example, attempted first-degree murder is a category 2 offense, whereas first-degree murder is a category 1. The same is true for rape. So if you are calculating guidelines for one of those more serious offenses that does involve an attempt conspiracy, you just want to make sure you're selecting the proper offense from MAGS, because we do have separate entries for those more serious offenses when they do involve conspiracy or solicitation. I'll highlight this again when we get to the MAGS demonstration. So moving on to part B of the offense score, that being victim injury. So it's defined in the guidelines manual as reasonable proof of injury, which may be physical or psychological, the cause of which is directly linked to the conduct of the defendant in the commission of the adjudicated offense. So non-permanent injuries are assigned 1 point, permanent injuries or death are assigned 2 points. We also further note that psychological injury shall be based on confirmed medical diagnosis or psychological counseling or treatment, and psychological injury is presumed not permanent unless otherwise demonstrated. Also noting that physical injury shall be more than minimal. Now, I will say with regards to calculating this component of the offense score, there can be some gray area. For example, we've been asked in the past if there was a victim of a stabbing, and if that victim sustained a scar as a result of that stabbing, would that constitute a non-permanent injury or a permanent injury? And the answer is that the instructions in our manual just do not get down to that level of detail. So ultimately, if you do encounter a scenario that may be a little bit gray, ultimately it's at the worksheet preparer's discretion as to the number of points that they score for victim injury. If the defense happens to disagree with that calculation, that should be brought to the judge's attention at sentencing, and ultimately the judge will decide the proper number of points that should be scored. All right, so regarding victim injury points, I have another true-false here. So true or false, permanent victim injury points should be scored for offenses involving photographic or video evidence of child pornography. I'm going to go ahead and launch another poll here. All right, so go ahead and make your selection. I'll read the question one more time. So true or false, permanent victim injury points should be scored for offenses involving photographic or video evidence of child pornography. Give you all just about 5 more seconds. Okay, let me go ahead and share the results here. Okay, so 90% think true, 10% think false. So let's take a look at the answer here. So the answer is true. So this language is intended to apply permanent victim injury points to any offense involving photographic or video evidence of child pornography. So just to note, it's not limited to solely adjudications for the possession, manufacture, or distribution of child pornography. This rule could also apply in cases involving the following types of offenses if evidence of child pornography is present. So that could be sexual solicitation of a minor, sextortion, prostitution, visual and camera surveillance of a private place, etc. So this was language that has been relatively recent. It's been a couple of years now, but really the scoring of the permanent victim injury points, it recognizes that photographic and video evidence of child pornography often exists in perpetuity, and that the victims of these crimes suffer lasting psychological consequences and are re-victimized every time an image is viewed, possessed, or distributed. So again, if you are calculating guidelines for a case that does involve photographic or video evidence of child pornography, permanent victim injury points should be scored. Okay, moving forward to part C, weapon presence. So weapon presence is defined as the presence of any article or device that reasonably appears capable of causing injury. So 1 point is scored here for a weapon other than a firearm, such as a knife or a BB gun. 2 points are scored for a firearm or an explosive. I also want to note, when calculating the offense score in general, a judge may include factors known to them when making this decision, even if they are not within the scope of the convicted offense. So for example, if you have a defendant who is charged with armed robbery but pleads to robbery, points may still be awarded for firearm or weapon presence in that particular case. All right, so before we review a recent update pertaining to weapon presence points, I have another poll question here. So how many weapon presence points should be applied when a weapon is feigned? Is that 0, so no weapon, or 1, a weapon other than a firearm? Let me go ahead and launch this poll. Give me 1 second here. All right, so how many weapon presence points are applied when a weapon is feigned? Is that 0, no weapon presence, or 1, a weapon other than a firearm? Give you all a couple seconds here. All right, let's go ahead and launch. All right, so 25% think 0, no weapon presence. 75% think 1 for a weapon other than a firearm. So let's go ahead and look at one of these recent updates here. Well, the answer is 1, weapon other than a firearm. And let's go and review some additional language that was recently added. So effective February 1, we modified the instructions for scoring weapon presence points when the offense involves the presence of a feigned weapon. So these revisions address an inconsistency that was brought to the Commission's attention by an assistant state's attorney. Our guidelines manual and COMAR, again, define weapon presence as the presence of any article or device which reasonably appears capable of causing injury. But prior to February 1, the instructions stated that the score should be 0 points if a weapon was feigned, but no weapon was actually present. So taken together, the instructions were a bit confusing because although feigned weapons are not real weapons, they can still appear reasonably capable of causing injury. So to eliminate that consistency, the guidelines manual and COMAR now provide the following instructions concerning feigned weapons. So if a weapon was feigned but no weapon was actually present, the score shall be 1, so a weapon other than a firearm. And a feigned weapon shall be scored 1 point when an individual intentionally creates the false impression that there is an actual weapon present, including a finger used to simulate a gun, a written note stating that there is a dangerous weapon present, or a verbal statement that there is a dangerous weapon present. So again, these modified instructions went into effect on February 1. And then wrapping up with Part D of the offense score, that being special victim vulnerability. So 1 point is scored here if the victim is younger than 11 or 65 years old or older, or if they have a temporary or permanent physical or mental disability, including an individual who's physically or mentally limited in a material way. So examples of a temporary physical or mental limitation could include instances when the offender knew or should have known the victim was pregnant, unconscious, asleep, or intoxicated. So again, if the victim meets any of this criteria, you would score 1 point for special victim vulnerability. All right, so that wraps up the offense score. Next, we're going to be moving on to the offender score. Now, the offender score is a summary scale ranging from 0 to 9, which measures an offender's criminal history, taking into account 4 factors. That being Part A, relationship to the criminal justice system when the instant offense occurred. B, juvenile delinquency. C, prior adult criminal record. And D, prior adult parole or probation violations. So before we review the criteria for Part A, I have another poll question here. This is probably one of the most common questions that I receive. So true or false, 1 point should be scored for Part A of the offender score, relationship to the criminal justice system when the instant offense occurred, if the defendant was on pretrial supervision at the time the instant offense occurred. So I'm going to go ahead and launch this poll. Okay, you can go ahead and start making selections. So true or false, 1 point should be scored for Part A of the offender score, relationship to the criminal justice system when the instant offense occurred, if the defendant was on pretrial supervision at the time the instant offense occurred. Just a couple more seconds here. All right, let's go and share the results here. Okay, so pretty split here. 60% think that this is true, 40% think false. And this is especially why I like highlighting this question in the trainings. So let's go ahead and take a look at the answer here. So generally the answer is false. Let's take a look at why that is. So the offender should receive 1 point if they were in the criminal justice system as a result of an adjudication as an adult at the time the instant offense was committed. So generally when someone is on pretrial supervision, they haven't yet been adjudicated of a particular offense. And that's why generally pretrial supervision wouldn't constitute criminal justice system involvement. However, in past trainings, we have had people bring up the fact that a defendant could be on pretrial supervision, adjudicated of a particular offense, and remained on pretrial supervision pending sentencing. So if the defendant picked up the instant offense after the adjudication of the offense and prior to sentencing, that would then constitute criminal justice system involvement. But again, generally, since pretrial supervision, it doesn't normally involve an adjudication, it wouldn't constitute criminal justice system involvement. All right, so moving on to Part D, juvenile delinquency. So 0 points are scored for juvenile delinquency if the offender is 23 or older by the date of the most recent instant offense, or if they have 0 findings of a delinquent act within 5 years of the date of the most recent instant offense. 1 point is scored if the offender is under 23 and has 1 or 2 findings of a delinquent act within 5 years of the date of the most recent instant offense. And then 2 points scored if the offender is under 23 and has had 3 or more findings of a delinquent act within 5 years of the date of the most recent instant offense. So a couple more items that I want to note with regard to scoring juvenile delinquency. The first is that only 1 finding of a delinquent act, that is, finding of facts sustained at an adjudicatory hearing, should be counted for a single adjudicatory hearing. So, for instance, if you have a defendant who may have been charged with robbery and possession of a firearm, they were adjudicated for both of these offenses during the course of 1 adjudicatory hearing, you would count 1 finding of a delinquent act instead of 2. And then finally, adjudications based on acts that are no longer crimes are excluded from the calculation of juvenile delinquency. All right, so moving on to Part C, prior adult criminal record. Probably the most complicated component of the offender score. So we're really going to break this down into great detail. Now, aside from a few exceptions that we have noted in our manual, that being violations of local laws, similar to juvenile delinquency, adjudications based on acts that are no longer crimes, those are exceptions, but generally the prior adult criminal record, it includes all adjudications preceding the current sentencing event, whether the offense was committed before, during, or after the instant offense or offenses. So another true false here. So only one adjudication per criminal transaction should be counted towards the prior record score. Is that true or false? Go ahead and launch this poll. You can go ahead and make a quick selection here. So true or false, only one adjudication per criminal transaction should be counted towards the prior record score. About 5 more seconds. All right, let's go ahead and share the results here. So we have 67% think true and 33% think false. So let's go ahead and take a look at the answer here. So the answer is true. Let's go ahead and break down the calculation of the prior record in greater detail here. Okay, this is going to be a lot. I'm going to go through each step, but then we're going to walk through a hypothetical prior adult criminal record in more detail in the next slide. So it all comes together. So step 1 in calculating the prior adult criminal record is going to be to identify the offense with the highest seriousness category for each prior criminal transaction. So if you have multiple adjudications that stem from the same criminal transaction, you're only counting the offense with the highest seriousness category. Step 2 is then to count the number of offenses in each seriousness category using only those offenses that you identified in step 1. Step 3 is then to refer to our criminal record matrix to identify the corresponding prior record level. Before we take a look at that, I do want to note that Maryland allows for what we refer to as a criminal record decay factor, meaning if a defendant has remained free of criminal justice system involvement, meaning they've been off parole, probation, etc., for 10 years prior to this instant offense, the criminal record should be reduced by 1 level. So if you initially calculate the prior record to be a moderate record, if the defendant meets this criteria for the criminal record decay factor, it would be reduced from a moderate to a minor. When we get into MAGS, I'm going to show you how to reflect that in the system properly. All right, so here's a screenshot of our prior adult criminal record matrix. This is what you use to determine the prior record level. So let's walk through a hypothetical prior record here. Let's say back in October of 2015, this defendant was adjudicated of a second-degree assault, which is a Category 5, as well as a wear, carry, transport of a handgun, which is a Category 7. Both offenses stem from the same criminal transaction. So again, I'm only counting the offense with the highest seriousness category, which is the second-degree assault here. Jumping down to July of 2018, there is then an adjudication for a burglary second degree, which is a Category 4. And then finally, in December of 2022, we have a destruction of property less than 1,000, which is a Category 7. So when determining the number of adjudications here, I'm looking at just the second degree assault, the burglary second degree, and destruction of property. Among those 3 adjudications, the one with the highest seriousness category is the burglary second degree, that being the Category 4. So I'm then going to look to the matrix here. I'm going to look to the seriousness category column on the left-hand side here. The highest seriousness category is a 4, so I'm going to look to this row here. Then at the top is the number of adjudications within that seriousness category. I have 1 seriousness category 4 adjudication, so I'm looking to this first column here. And we can see, based on the criteria, initially the prior record is calculated to be immoderate, but would jump to a major if combined with 2 or more offenses in categories 4 through 6, or any 6 offenses in general. So the rest of the prior record doesn't meet the criteria for a major, which means this would result in a moderate record level. So I know that was probably a lot. Hopefully it was helpful to walk through a hypothetical scenario. As I mentioned before, this is definitely probably the most complicated component of the offender score. If you ever have questions about calculating the prior record, you can feel free to reach out to us. Just one final thing to note regarding calculating the prior record, you want to use the offense seriousness categories that are in effect at the time of sentencing. So some of these drug-related offenses, for example, like possession of cocaine, it had a higher seriousness category years ago, but has since been reduced to a seriousness category 7 as a result of the penalty changes that went into effect pursuant to the Justice Reinvestment Act. So that's just something to keep in mind. You want to make sure you're utilizing the seriousness categories currently in effect at the time of sentencing. And then wrapping up with Part D of the offender score. So 1 point would be scored here if the offender was ever adjudicated in violation of parole and probation, or was adjudicated of an offense while on parole or probation, unless the adjudication arose from the offense or offenses of this sentencing event. All right, so moving on to the guidelines range, recommended guidelines ranges. So when viewing the worksheet, I already pointed this out before. You can see there's space for 3 offenses as well as 3 individual guidelines ranges. And then down below here is the overall guidelines range. So based on how you enter information into MAGS, the application is automatically going to calculate the individual and overall guidelines range for you. So we're just going to take a look at a couple of examples of how the guidelines range is adjusted due to special circumstances in a case. So let's start with the multiple victim stacking rule. So here's an example of where the overall guidelines range is adjusted due to a case involving multiple victims within a criminal event. Again, we refer to this as our guideline stacking rule. So in this type of case, the guidelines range for each individual offense is still calculated as normal. But instead of using the highest of the upper and lower guidelines limits, those who remember manual calculation of the guidelines, instead, the highest of the lower limit is taken, and the upper limit for each offense involving a unique victim is instead added or stacked. So in this example, let's say we have an individual who was adjudicated of 3 counts of second-degree assault, each involving a unique victim. They all originate out of the same criminal event. So the overall guidelines range for this event would be adjusted to account for the 3 separate victims. So in this example shown here, the overall guidelines range would be adjusted from 2 years to 5 years to 2 years to 15 years to reflect the involvement of 3 separate victims in the event. So just to recap the criteria for utilizing the stacking rule. 1, there must be a criminal event with multiple distinct victims. There cannot be more than 1 seriousness category 1 or 2 offense. So for example, if you had 2 first-degree murders, you couldn't utilize the stacking rule because by other guidelines rule, those ranges would be added together. 1 adjudicated offense per distinct victim may be used to calculate the overall guidelines. So if you have multiple offenses that relate to the same victim, you're only stacking 1 of those offenses, that being the most serious offense among the victim. And finally, only the upper limits stack. Now, here's another recent update that I want to highlight here, some clarifying language. So true or false, animals are considered victims for the purposes of the multiple victim stacking rule. Is that true or false? Let me go ahead and launch this poll question. All right, so true or false, animals are considered victims for the purposes of the stacking rule. Just a couple seconds here. Okay. Let's go ahead and share these results. So 33% think that this is true, 67% think false. So let's go ahead and take a look at the answer here. So the answer is false. So in response to multiple inquiries questioning whether the stacking rule may be applied in a criminal event with multiple counts of animal cruelty, each involving a different victim, the commission considered this issue of animals as victims and concluded that most definitions of the term victim specifically cite references to a person or an individual and do not outwardly encompass animals. So as such, effective February 1 of this year, clarifying language was added to the guidelines manual that explicitly excludes animals from the multiple victim stacking rule. So if you are calculating guidelines for a case that involves, one criminal event, multiple counts of animal cruelty, involving different animals, you could not utilize the stacking rule in that particular instance. All right, so moving forward to the subsequent drug offender enhancement. So in this example illustrated here, we show a case where the offender was adjudicated as a subsequent drug offender pursuant to Criminal Law Article 5-905. So in this example, the offender was sentenced for a distribution of cocaine adjudication, which is a Category 3B offense. Now, if the offender had a hypothetical offender score of 3, the range in this example would have been 3 months to 3 years. However, because this offender was convicted as a subsequent drug offender pursuant to Criminal Law Article 5-905, the guidelines range for that offense is doubled. And per statute, the statutory maximum for the distribution offense also doubles and increases from 20 to 40 years. And again, when we get into the MAGS demonstration, I'm going to show you where you can apply all of these enhancements that I'm discussing right now. All right, and finally, wrapping up with one last special application that I want to highlight. So this is a special application that went into effect earlier this year on February 1. So the Commission adopted instructions to stack the upper guidelines limits in criminal events involving an offense with a statutorily mandated consecutive sentence. So the instructions specify that when there's a criminal event with multiple offenses and the sentence for one of the offenses is statutorily required to run consecutive to the sentence for another offense in the same criminal event, the person completing the sentencing guidelines worksheet shall add the upper limits of the guidelines ranges for the offense with a mandatory consecutive sentence and the offense to which its sentence must run consecutive to obtain the upper limit of the overall guidelines range. I know it's a mouthful. In this example here, we show a case involving committing a crime of violence in the presence of a minor, a robbery, and an assault second degree. Now, by statute, the sentence imposed for committing a crime of violence in the presence of a minor, it must run consecutively to another offense within the same criminal event. In this case, it's to run consecutive to the robbery, which is the underlying crime of violence. So therefore, the upper limits for both committing a crime of violence in the presence of a minor and the robbery are added or stacked to obtain an overall guidelines range of 3 years to 13 years. This is another update that went into effect in MAGS. Well, the guidelines rule went into effect in February 1, but MAGS was not programmed to account for this scenario until its MAGS 12.0 release on July 1. So this is going to be a special application that I'm going to walk through in my MAGS demonstration to show you how MAGS accounts for this type of scenario. All right, so wrapping up with the last couple sections of the worksheet, the next section that you see highlighted here, this is the victim information section. These questions pertain to the rights of victims at sentencing. The State Board of Victim Services has asked us to collect this information. So again, we just ask practitioners to complete this information for any case involving a victim. And finally, the remaining fields that you see highlighted here, these are the sentencing and departure related fields that are typically completed by the judge or their designee post-sentencing. So this includes disposition type, sentence information for each individual offense, whether victim court costs were imposed, etc. All right, so before we get into the MAGS demonstration, I'm going to wrap up by reviewing how to determine if a sentence is a guidelines compliant sentence. Now, a sentence is deemed compliant with the guidelines if the guidelines applicable sentence, which is defined as the sum of incarceration, credited time, and home detention time, falls within the applicable guidelines range. So generally, suspended time is not considered when determining whether a sentence is compliant with the guidelines. There's one exception involving corrections options. We'll talk about that in a moment. But again, generally, it's going to be the sum of incarceration, credited time, and home detention time that's used to determine compliance. I also just want to note that compliance is calculated by comparing the overall total sentence across all adjudicated offenses in a sentencing event to the overall guidelines range for the sentencing event. So it's possible that the sentence could exceed the upper guidelines limit for one offense, fall below the lower guidelines limit for another offense, but the overall sentence, when taking into consecutive considerations and whatnot, the over sentence could fall within the overall guidelines range for that particular sentencing event. So there are a few qualifiers to consider regarding guidelines compliance. The first is that sentences adjudicated pursuant to an MSCCSP binding plea agreement are automatically deemed guidelines compliant. So some of you who may be practicing for a couple of years by now, you might remember the former ABA plea agreement, but it's important to note that that former ABA plea agreement disposition, it has been replaced with MSCCSP binding plea agreement. And the criteria for what constitutes a guidelines compliant MSCCSP binding plea has also been revised. Now, the MSCCSP binding plea compliance rule, it follows the same logic as that former ABA plea agreement compliance rule, which was initiated based on feedback received from the judiciary that binding pleas represent a consensus of the parties in the court within their specific community. So accordingly, the commission felt it was important to define these as compliant sentences. Now, binding pleas are three-party agreements in which the defense and the state present to the court on the record an agreement that incorporates a specific sentence. And if the judge accepts that agreement, it becomes binding on the court pursuant to Maryland Rule 4-243 subsection C. Now, effective April 1 of 2021, the commission narrowed the definition of what constitutes a guidelines compliant plea and adopted language to specify that an MSCCSP binding plea agreement is a plea agreement presented to the court, an agreement by an attorney for the government and the defendant's attorney, or the defendant when proceeding pro se, that a court has approved relating to a particular sentence disposition. So an MSCCSP binding plea agreement means an agreement to a specific amount of active time, if any, not merely a sentence cap or range. The court has the discretion to accept or reject the plea, and the agreement becomes binding on the court under Maryland Rule 4-243 subsection C if the court accepts the plea. That was a lot to take in. Let's kind of apply that knowledge to a couple of hypothetical sentencing scenarios here. So let's say the guidelines for the sentencing event are 2 years to 8 years. The state and the defense present to the court a plea agreement to a sentence range anywhere from probation to 2 years. The court accepts this agreement and sentences the defendant to 3 years to spend all but 1 year. Is this an MSCCSP binding plea agreement? I'm going to go ahead and launch that poll real quick. All right, I'm going to read it one more time while you all make selections here. So the guidelines for the sentencing event are 2 years to 8 years. State and defense present to the court a plea agreement to a sentence range anywhere from probation to 2 years. The court accepts this agreement and sentences the defendant to 3 years to spend all but 1 year. Is this an MSCCSP binding plea agreement? All right, let's go ahead and share responses. So we have 44% think yes and 56% think no. So let's go ahead and take a look at the answer here. So the answer to this scenario is no. So as a reminder, an MSCCSP binding plea, it must involve an agreement to a specific amount of active time, if any, and not merely a sentence range or a cap. So in this particular scenario, the court accepted a plea agreement to a sentence range, anywhere from probation to 2 years. So this is why it would not constitute an MSCCSP binding plea agreement. Let's look at another scenario here. Let's say the guidelines for the sentencing event are 1 year to 6 years. The state and defense present to the court a plea agreement to 5 years, all suspended, with credit for 62 days. The court accepts this agreement and sentences the defendant to 5 years, all suspended, with credit for 62 days. Is this an MSCCSP binding plea agreement? Okay, launch that one. This is the last poll question. So the guidelines for the sentencing event are 1 to 6 years. State and defense present a plea agreement to 5 years, all suspended, with credit for 62 days. Court accepts the agreement, sentences the defendant to 5 years, all suspended with credit for 62 days. Is this an MSCCSP binding plea agreement? All right, let's go ahead. So we have 78% say yes, 22% think no. So let's go ahead, take a look at the answer here. So the answer is yes. So in this scenario, there was an agreement to a specific amount of active time, that being 0, or in other words, like no post-sentence incarceration. So therefore, this would constitute an MSCCSP binding plea agreement. So hopefully seeing those two different scenarios helped kind of bring all of that information and digest it a little bit more. But if you ever have a question, you can always reach out to our office as well. One last sample scenario that I want to highlight, this isn't a poll question, but let's just say the guidelines for the sentencing event are 1 year to 5 years. State and the defense present to the court a plea agreement to a sentence range anywhere from 2 years to 4 years. The court accepts this agreement and imposes a sentence of 5 years, suspend all but 2 years. So while this particular agreement is not an MSCCSP binding plea agreement, right, because the agreement was to a sentence range, so it wouldn't be an MSCCSP binding plea agreement, but the sentence itself is still guidelines compliant, since the guidelines applicable sentence of 2 years falls within that overall guidelines range of 1 year to 5 years. So all that to say, it is still absolutely possible to have guidelines compliant sentences that are not adjudicated via an MSCCSP binding plea. So moving on to corrections options. Sentences to a corrections option program are guidelines compliant, provided that the initial sentence plus any suspended sentence, so as long as the total sentence falls within or above the applicable guidelines range, and the case does not involve a crime of violence or escape. So this is the one exception I mentioned earlier, where suspended time is considered for determining a guidelines compliance. So corrections options allow judges to utilize a broader range of alternatives to incarceration while still remaining compliant with the sentencing guidelines. So corrections options include home detention, inpatient residential treatment, inpatient drug or alcohol counseling under health general orders, drug court, participation in any problem-solving court, a sentence with required substance abuse treatment for the possession of controlled dangerous substances, work release, or weekend or other discontinuous incarceration. So again, if you have a defendant sentenced to one of these corrections option program, as long as the total sentence falls within or above the applicable guidelines range and the case doesn't involve a crime of violence or escape, it would be deemed guidelines compliant. And then the last rule regarding guidelines compliance is that sentences in which the offender received credit for time served with no post-sentence incarceration, and if the amount of credited time exceeds the guidelines range, it's deemed guidelines compliant. So for example, if you have a guidelines range that's probation to 3 months, the sentence is 6 months fully suspended with credit for 100 days, the sentence is still guidelines compliant, even though that credited time exceeds that upper guidelines limit. All right, so that wraps up guidelines compliance. We're going to start moving into our MAGS demonstration. Before I do that, I do just want to point out our guidelines calculator tool. You can see here's a screenshot of our homepage here. To access the guidelines calculator tool, you would simply just click on this GLCT icon. Now, the guidelines calculator tool is a standalone tool that can be utilized by anyone to calculate sample sentencing guidelines. It's essentially a simplified version of MAGS. So you can see here's a screenshot of the offender information, offender score, list of offenses. It is identical to what you would see in MAGS. However, you don't need a user ID, you don't need a password to utilize the guidelines calculator tool. The only caveat is that it does not save and store information like the MAGS system does. So if you utilize the tool, you want to make sure you're printing out a copy of the sample guidelines worksheet or saving it to your computer, because once you exit out of your browser, you're gonna lose that information. But I wanted to point this tool out. I know state's attorneys utilize this tool, maybe in plea negotiations, just calculating various sentencing guidelines. Important to note that ultimately you will have to officially initiate a sentencing guidelines worksheet in MAGS. But if you're just looking to calculate sample guidelines, you can utilize this tool. A lot of defense attorneys also love using this tool. It enables them to calculate their own sample sentencing guidelines as well. So that said, I am going to be jumping into the MAGS demonstration shortly. If there are any defense attorneys who are attending this training, I really encourage you to stay and view the MAGS demonstration, because everything that you see me doing in MAGS can be used in the guidelines calculator tool to initiate sample guidelines worksheets. So it is still relevant to you, even though you don't officially initiate worksheets in the MAGS system. So really quick, here's a screenshot of our MAGS homepage. We have a couple of instructional and support materials. We have a MAGS user manual, frequently asked questions, instructional videos. We have two. The first is geared towards state's attorneys, parole and probation agents, which focuses on initiating a guidelines worksheet in MAGS. Second is geared more so towards judges and their designees, and it shows you how to enter sentence information and submit worksheets through MAGS. So if those are helpful to you, if you have a new colleague who comes on board, please advise them to check out the MAGS homepage here. And then generally, you would just be accessing MAGS by clicking the MAGS login button. So at this point in time, I'm going to go ahead and bring up MAGS. Just bear with me 1 second here. Okay, so hopefully you all should be seeing the MAGS login screen here. So I'm just going to start by entering my user ID, which generally everyone's user ID, it's going to start with a prefix that corresponds to their individual agency or jurisdiction. There are some exceptions now with some of the state's attorney's office, but generally you all are still utilizing some prefix. So I'm just going to go ahead and log in with my username here, as well as my password. Okay, so now you should be seeing the MAGS home screen. And again, I know it might be a little small, so hopefully just try to bear with me here throughout this demonstration. So from the MAGS home screen, this is where users can either create a new worksheet or you can view, edit, or delete an existing one. One particular feature that I want to point out that was recently deployed with this MAGS 12.0 release on July 1 is this reconsideration modification or 3-judge review for COV sentences feature. So this is particularly helpful for state's attorneys. As we talked about before, we also collect sentencing guidelines worksheets for reconsiderations, modifications, 3-judge panel reviews, as long as they involve a crime of violence and there was an adjustment made to the original active sentence as a result of that modification. Now, for those of you who may have been utilizing MAGS for some time, prior to July 1, you did have to initiate a new worksheet for an upcoming reconsideration or modification. You were pretty much copying the information that was submitted on the original worksheet, but you did have to go through the whole process of initiating a brand new worksheet. This feature here is going to streamline that worksheet initiation process for you. If you are trying to initiate a worksheet for an upcoming reconsideration, modification, or review. So let me show you how it works here. Let's say you have an upcoming reconsideration. Maybe you even know that the original worksheet or the worksheet for the original sentencing event was submitted through MAGS. So to quickly initiate a copy of the original worksheet, you would first just check this little box next to reconsideration modification. You can see once I do that, most of these search features are going to be grayed out, just leaving you with the case number. So I am then just going to go in and enter the case number and then click search here. So you can see once I click search, if I look under the submitted column, I can see the original worksheet from 2021 was submitted here. Since I'm commission staff, I do have, I see more icons than you will be seeing for a submitted worksheet, but you will see this little copy icon here. If you simply click copy, it's going to ask you if you want to copy the worksheet and you simply click OK. So once you do that, you're going to be brought to the offender information tab. And if I scroll down here, you can see that all of the information that was submitted on the original worksheet, it's going to pre-populate here. Most of it is going to be disabled and grayed out because the guidelines should be the same as they were for the original sentencing event. So you're not going to be able to make edits to most of this information. That said, worksheet preparer and title, that's going to be a blank field, so you are going to need to enter your information here. So I'm going to go ahead and enter that. I'm just going to select other. The only other fields that you may be prompted to complete would be ethnicity and race. So those did not become mandatory fields until, I believe it was 2021. May have been a little bit earlier. So if the original worksheet was submitted prior to these becoming mandatory fields, they may have been submitted without this information. So now that they are mandatory in MAGS, you are going to be prompted to make a selection before you can continue. So I'm just going to click Save This Page here. I'm just going to quickly kind of scroll through the offender score so you can see this pre-populates with the information that was originally submitted. It's grayed out. I can't make changes. Same with the list of offenses. I can't add any offenses. I can't make edits to the original offense. This is just to ensure that the guidelines remain the same as they were for the original sentencing. So really the last tab that you may need to complete prior to the upcoming reconsideration would be the victim information, which we'll go into a little more detail about that when I show you how to initiate a worksheet. So that is how you would utilize that new feature. I hope we've gotten good feedback in response to it, so I hope you all will find that feature very helpful when it comes to initiating worksheets for reconsiderations. It really takes out a lot of the work that you used to have to do for those types of cases. Okay, so coming back to the home screen here, I already kind of touched on these, but the various search features that we have here, I want to encourage everyone to search the MAGS system before initiating a new worksheet. This is especially true with state's attorneys and parole and probation investigators, because it's possible maybe the state's attorney initiated a guidelines worksheet for a particular case, not knowing that a pre-sentence investigation was going to be ordered. So instead of creating duplicate worksheets, which gets very confusing for judges and their designees, when they go to enter sentence information, if there are discrepancies, they may not know which worksheet to ultimately submit. So we really want to try to avoid duplicating any worksheets. So that said, if you search the system, find that maybe in that particular scenario, the state's attorney initiated the worksheet. If parole and probation views the worksheet, they agree with the calculation, you can pretty much leave it as is in the system. I know some investigators like to write their name in it since they are officially responsible for conducting the pre-sentence investigation. However, if parole and probation views the guidelines calculation by the state, maybe they don't agree with it, maybe they found additional offenses that they need to apply towards the prior record, we then ask that you reach out to the state's attorney or vice versa and just have a conversation in hopes of reaching a consensus regarding the scoring of the guidelines, as opposed to just duplicating and initiating another worksheet. So that said, there are a couple of different ways you can search the system. You can filter entirely by jurisdiction. You can enter the state identification number, first name, last name, or case number of the defendant, or you can search by worksheet ID number, which I'm going to talk about in a moment here. So I'm going to go ahead and just filter. I already know I had a little test case right here. I'm going to filter by Baltimore County and search for an Edward Smith here. So you can see once I do that, I see two results. I have two different case numbers, one ending in 1122, one ending in 1155. If I look to this worksheet ID column, I can see that they are linked and share the same worksheet ID number of 167264. Now, I'm going to sound like a broken record by the end of this training, but when you have multiple criminal events that are often indicated by different offense dates, most likely different case numbers, when you have multiple criminal events sentenced in front of the same judge on the same day, only one set of sentencing guidelines should be initiated for them. Meaning when you go to initiate that worksheet, you click this Add New button one time. And when you get to the List of Offenses tab, that's where you can add all of that unique case number information. If a multiple criminal event, single sentencing event scenario is initiated properly in MAGS, if you were to look up this defendant or even one of these case numbers, you should see all of those unique case numbers linked to the same worksheet ID. You shouldn't have to search for different case numbers. And again, when you get to the list of offenses tab, if you didn't see all of those multiple case numbers, that's an indication that it was not initiated properly. So I mentioned this and really harp on it for two reasons. The first is because if they were initiated separately, the judge isn't presented with a proper overall guidelines range. The second issue comes when it comes to entering sentence information and submitting the worksheet. So law clerks, judges and their designees, they'll be able to enter sentence information for these cases. If they're initiated separately, they'll be able to submit the worksheet for the first case, but then they're going to get a duplicate error message upon attempting to submit the second worksheet. It's going to say, wait a second, there's already been a worksheet submitted that contains the same SID number, date of birth, and date of sentence. That's MAG's way of saying, wait a second, these probably were a part of the same sentencing event. They were initiated separately, but I'm not accepting the second worksheet because they need to be combined under one worksheet ID. So then judges and their designees reach out to us. We have to combine it for them and send them back a revised PDF. So again, really, the most important thing is that judges are presented with this proper overall guidelines range. So it's incredibly important that this type of scenario is initiated properly in MAGS. So at this point, I am going to show you how to initiate a multiple criminal event, single sentencing event scenario in MAGS. So let's say I search the system, I don't see the case that I want to initiate guidelines for. So I'm going to start by initiating a brand new worksheet by clicking Add New here. It's always going to ask you to use the search feature to confirm a worksheet hasn't been initiated. And again, noting that one worksheet should be created for multiple event or offense cases sentenced on the same day by the same judge. And I say, okay. All right, so whether you're editing a previously initiated worksheet, copying an original worksheet, or creating a new worksheet, you're always brought to the offender information tab first. So you can see MAGS, we have it divided here. Different sections of the worksheet that we just talked about are broken up into different tabs. So starting with offender information, very self-explanatory. This is where I'm just entering information about the worksheet preparer, as well as the defendant. So, and enter this demographic information. Oops. Whoops. Whether a pre-sentence investigation was ordered, jurisdiction, we'll see in Arundel, representation, ethnicity. And I do want to note that we do allow for multiracial responses. So you can select more than one race in this field here. So I'm going to go ahead and click Save this page. All right, so moving on to offender score. Again, we already went through each of these components, so I'm not going to talk about them in too much detail here. Throughout MAGS, you'll see that we have these information icons. By clicking on the icons, it gives you an expanded explanation of the particular field and the criteria for scoring that field. So all of the information is taken directly from our manual. If you ever have a question about what we're trying to capture, please utilize these icons. They are extremely helpful. So part A, relationship to the criminal justice system when the incident offense occurred. I will note that this is scored at the offense level, because if you do have a sentencing event that involves multiple criminal events, sometimes those criminal events can span quite a good deal of time. So it's possible the defendant may have been under criminal justice system involvement when one of the offenses occurred, but not when the other one occurred. So this is scored at the offense level. We'll talk about that when we get to it. So I'm just going to score juvenile delinquency here. Prior adult criminal record. Just want to note that this is a clickable link. If you click on it, it brings you to our criminal record matrix, as well as the criteria here. So jumping back, I talked earlier about the criminal record decay factor. So how you want to reflect that in MAGS. You want to first score the criminal record as you calculate it. So let's say initially this defendant's prior record was scored as a moderate, but they meet this criteria for the criminal record decay factor. So I do want to apply it. So you would just simply click this yes radio button, and you can see once I do that, it jumps from a moderate to a minor. And then when we view the worksheet, you'll actually see the words decay factor populate on the worksheet to indicate that it was utilized. And then finally, prior adult parole and probation violations. So I'm going to click save this page and then moving on to list of offenses. So list of offenses, this is where you're entering all of the adjudicated offense information. Even if you have different case numbers, multiple criminal events, all of that is going to be entered on this tab here. So to start, I'm going to click add offense, which brings me to the offense offender score screen. So upper left-hand corner, you start by entering the event number. I talked earlier about how it's important that you're properly noting criminal event numbers in MAGS, so it knows how to calculate the overall guidelines. So in this test case that I'm going to show you, there's going to be 2 criminal events, 2 offenses within each criminal event. So I'm going to start by entering the information for criminal event number 1. So this is criminal event number 1. And then the count number, you want to list the count number that corresponds to the offense as it's reflected on the indictment. So instead of just listing count 1, 2, 3, 4, 5 in sequential order, you want to actually note the count number as it's reflected on the indictment. And then moving forward to the offense date. So let's just say this is February 1 of this year. And then I'm going to enter the case number here. All right, so jumping down to offense title, 2 different ways you can search. You can click this most common offenses button, which brings you to our 25 most common guidelines eligible offenses. Or you can click the search button, which brings you to our entire offense table. From here, you can further search by offense title, CJIS code, statute, or type. So person, property, or drug. While I'm in here, I'm just going to quickly show you, when I mentioned earlier, the conspiracies, attempts, solicitations, how when those are involve one of the more serious offenses, how we have separate offense entries. So just real quick, if I were to click search for murder in this general search field here, you can see that there are separate entries for attempt, conspiracy, or solicitation here. So I did just want to point that out while I was in here. Okay, jumping back. So utilizing this search field, you can simultaneously search all of these columns that I just talked about by utilizing the main search field. So let's just say I want to search for an assault, 1st degree. As soon as I type in the word assault, any offense containing that word is going to populate here. And I can pretty easily just scroll down and see assault 1st degree, and I'm going to click select. And once I do that, you can see MAGS populates the seriousness category, CJIS code, statute, stat max, and if there were a mandatory minimum, that would populate here. So generally, any attempt, conspiracy, or solicitation, it's going to be assigned the same seriousness category as the underlying offense, with the exception that we just talked about. So generally, you would just be selecting the underlying offense, and then if this happened to involve a conspiracy or an attempt, you could make that selection here. So jumping over to enhancements, if I click the drop down here, this is where you can apply that subsequent drug offense enhancement that we talked about earlier, as well as if a defendant's been convicted as a subsequent with a subsequent crime of violence, and then therefore subject to the 10, 25-year or life mandatory minimum, or a repeat sex offender and subject to the life max, you could apply that enhancement from here. Now, the multiple victim stacking rule, this is how you would flag an offense for the multiple victim stacking rule, which I am going to do in this particular case. So I'm going to go ahead and say, yes, this was an assault 1st degree that involved 1 distinct victim. MAGS is always going to give you the criteria that you need in order to apply the stacking rule, and you would just simply click OK. Now, this is a new feature that we deployed with MAGS 12.0 in July. You will now, when you apply an offense for the stacking rule, you will note the victim number corresponding to that offense. This is just to ensure that you're flagging 1 offense per distinct victim. So in this particular case, I'm going to say yes for victim number 1. All right, so jumping down to offender score. Part A, relationship to the criminal justice system when the incident offense occurred. I'm going to say 0. And then jumping over to the offense score. We talked about how the offense score is completed for person offenses. Assault 1st degree is obviously a person offense. MAGS will calculate part A, the seriousness category for you, just based on the seriousness category of the underlying offense that you select. And then you would just continue to make selections for victim injury, weapon presence, and special victim vulnerability. And then you would click calculate guidelines range. which gives you the individual guidelines range for the offense and updates the overall guidelines range for the sentencing event as you add offenses. So I'm going to click Save this page and close. All right, so there I have my first offense, the assault first degree. Now I'm going to go back in. I'm going to add a second assault first degree offense that involves a different, unique victim. However, it occurred at the same time as the assault I just entered information for. So it's still going to be a part of criminal event number 1. However, this is going to be count number 5. So it's going to have the same offense date as what I just entered and the same case number. I'm just going to click on most common offenses because I know this is the first offense here. All right, I'm not applying any sort of enhancement or anything like that. I am going to jump down to the stacking rule. I'm going to say, yep, I need to apply it here. And you can see once I do that, victim number 1, I've already used it, so it no longer appears. So I'm going to note that this corresponds to victim number 2. Scrolling down, again, make your selection for part A of the offender score, and then make your selections for the offense score. And then click Calculate Guidelines, saving this page, and close. All right, so here I have my individual guidelines range, 4 years to 9 years for each of those offenses. And the overall guidelines range, you can see that since I applied the stacking rule, it's adding those upper limits for each unique victim, which gives me that 4 years to 18 years range. All right, so now I'm going to add 2 more offenses that correspond to a second criminal event. It occurred on a different date and involves different offenses. So I'm still going to go ahead and click Add Offense here, except I'm going to make sure that this is part of criminal event number 2. And let's just say this is count 1 within criminal event number 2. So this is going to have a different offense date as what I just entered. It's also going to have a different case number. So let's just say 2, 3, 4, 5, 6. Okay. Now, convicted offense title, I'm looking for a distribution of heroin, which from the most common offenses, I know I have my distribution of heroin in there. So I'm going to click Select. And then jumping down to the offender score, I'm going to make my selection for Part A here. Now, distribution of heroin is a drug offense, which means I don't need to calculate the offense score. I simply just jump down and click Calculate Guidelines Range, and then saving this page and close. All right, adding 1 more offense to criminal event number 2. So this is still going to be criminal event number 2. Let's say this is count 4. So it has the same offense date as what I just entered for the distribution and the same case number. Okay, now this one I'm going to look up. Now, this is going to be a knowingly violating criminal law 5-602 with a mixture of heroin and fentanyl. So I'm going to go ahead and just select this here. Jumping down to Part A of the offender score. Again, a drug offense, so I simply just go down and click Calculate Guidelines Range. So now you can see MAGS prompts me by saying, wait a second, this is a mandatory consecutive offense, and we need to select an offense for this to run consecutive to. So by statute, the sentence for this knowingly violating offense, it does need to run consecutive to another offense in the same criminal event. So now MAGS is prompting you to link it to another offense within the same criminal event to make sure that the upper limits for these 2 offenses are added or stacked. So you can see if I click the drop down here, I see the distribution of heroin populate, which is the only other offense in this same criminal event. Let's just say I ignore that and click Save this page and close. I don't want you to ignore it, but I want to show you what happens if you do. So clicking Save this page and close. MAGS says, wait a second, there's an offense that still has a warning here. We can see this little triangle that appears next to the knowingly violating offense. If I click on that little triangle, it's telling you the mandatory consecutive offense is missing. Would you like to select one? And you state, okay. Jumping back, it brings you back to this drop down that we just talked about. And from here, this is where I can link it to the distribution of heroin. And then go down, click Calculate Guidelines Range, save this page, and close out. So now it's satisfied and that little alert message disappeared. So again, that's how the mandatory consecutive sentence, that new rule, will appear in MAGS. All that to say, there's only about 10 offenses where you that involve these mandatory consecutive sentences for guidelines purposes. So it'll be rare for you to see that alert and have to link it to other offenses. But if you do calculate guidelines that involves one of these offenses, this is how MAGS accounts for that scenario and how you would want to link it. Okay. Last tab really quick is victim information. Pretty self-explanatory. This is where we're collecting information about the victim rights at sentencing. So we do ask that state's attorneys, parole and probation complete as many fields as they can prior to sentencing. That said, there are some fields that can't be completed until after sentencing. For example, whether the victim was present, if they gave a written or oral victim impact statement. So those are completed by the judge or judge's designee post-sentencing. If you ever have a question, just utilize these icons. It tells you exactly what we're asking here. All right. So at this point in time, I've initiated my multiple criminal events, single sentencing event scenario. I'm going to click View Worksheet PDF, and we're going to see what this looks like here. Okay, so in viewing the worksheet here, I can see clearly my criminal event number 1 involves the 2 first-degree assaults. I can clearly see victim 1, victim 2. I can see the decay factor was applied. And then scrolling down, because again, when we have multiple criminal events, each separate criminal event should correspond to their own worksheet. It's another question I get when people view the PDF. They wonder where the other criminal events are, and it's because they're on their own worksheet. So you may be required to scroll. So jumping down here, I have my distribution and knowingly violating offense. Okay, so that pretty much wraps up the MAGS demonstration for initiating guidelines worksheets. The one last thing I want to point out before I just jump back and talk about some resources, and then we'll conclude for the day, is merged and null prost offenses. So if you know that an offense is going to be merged or null prost, or find out at sentencing, we really do ask state's attorneys to go back and delete those merged or null prost offenses from the list of offenses tab, just to ensure that all of the proper information is in MAGS by the time the law clerks and judges get in to enter sentence information. So in this particular case, like, let's just say this knowingly violating offense ended up being null prost or merged at sentencing, so I want to remove it. You would simply just click the little trash can icon next to the offenses tab. I'm sorry, next to this particular offense, and confirm you want to delete it. That's it. That's all that has to be done. So that's the last thing I wanted to point out here. Okay, so that wraps up MAGS. I'm just going to quickly bring up our resources, and then give me 1 second here. Okay, I just want to wrap up by highlighting a few of our commission resources. So the MSCCSP website, it's continually updated throughout the year. It's a really useful resource for individuals who implement the sentencing guidelines. So our websites include annual reports. They're a great resource to learn more about recent sentencing trends and the work of the Sentencing Commission. We also have our guidelines e-news, which helps to inform about changes to the guidelines. Those can be accessed from our website. If you don't currently subscribe to our listserv and would like to, just shoot us an email on our general email account. Let us know you'd like to be added to the listserv so that you will receive these guidelines e-news. They're really important to highlight changes to the guidelines. So more recently, we started producing topical mini reports that we title Sentencing Snapshots to provide quick review of sentencing trends and other topics of interest. The most recent issue provided a closer look at sentencing trends for juveniles in Maryland circuit courts, and those are also available on our website. Also provides access to guidelines manual, guidelines offense table, MAGS, and the guidelines calculator tool. We have various instructional videos and recordings of guidelines training webinars available on our training website. Also, if you just go to our YouTube channel, if you go to YouTube, type in MSCCSP, you'll see all of our videos there. Finally, we have a crime violence data dashboard, which provides key characteristics for guidelines eligible crimes of violence sentenced in the circuit courts in fiscal years 2022 and 2023. And lastly, we launched a data download tool in March of this year. It provides even easier access to available sentencing guidelines data. So our data can be accessed and downloaded from our website. Finally, the commission staff, we provide help desk that's manned from 9 to 5 every day during the week. You can either reach us at 301-403-4165 or via email at msccsp@umd.edu. If you reach out over phone or via email, you probably know I'm the first point of contact. Some of us may have spoken many times at this point, but I'm always happy to help. So really, any questions about the guidelines, please feel free to reach out. So with that concludes the webinar. I just want to check in really quick with Sarah to see if there's anything outstanding that we want to address before we conclude.
No, I don't have anything outstanding. I did put one more copy of today's presentation in the chat box if anyone's interested.
Thank you, Sarah. I think we have maybe 4 minutes. Does anyone have any last minute questions that they'd want to ask before we conclude today? No pressure, just want to give everyone the opportunity. Okay, sounds good. Okay, well, thank you again for attending. I know this was a ton of information, but I hope you all found it informative and helpful. And again, please just feel free to reach out to us for any questions in the future. And with that, I hope you all have a great rest of your day. Have a good one.